Now let's talk about the remedy of rescission in sales of immovables. When the buyer fails to pay the price of a contract of sale, one of the remedies of the seller is rescission. On the other hand, the buyer is entitled to retain the purchase price if the seller fails to perform any essential obligation of the contract. Such rights are premised on the general principle of reciprocity of contracts. Rescission, or to rescind, is to declare a contract void at its inception. It is not merely to release the parties from further obligations to each other, but to restore the parties to their positions as if no contract has been made. When the seller refuses to accept payment, the buyer may consign the purchase price with the court, provided that there had been no previous receipt of a demand for rescission. Such consignation is sufficient to defeat the right of the seller to demand for a rescission of the deed of absolute sale. Now let's distinguish an affirmative judgment in an action for rescission and in an action for reconveyance. Judicial rescission gives rise to mutual restitution, wherein the parties restore to each other the things which have been the subject matter of the contract, their fruits, and the price with interest. This is not necessarily the situation in an action for reconveyance. Moreover, unlike in an action for reconveyance, in an action for rescission, the court may authorize for a just cause the fixing of a period such as in accordance with the Masada law, which provides that the actual cancellation must be 30 days from the notice of cancellation. A contract of sale may either be absolute or conditional. One form of conditional sale is a contract to sell, where ownership or title is retained until the fulfillment of a positive suspensive condition, normally the payment of the purchase price by the buyer to the seller in the manner agreed upon. Now let's distinguish contract to sell from conditional contract of sale. When there's fulfillment of the suspensive condition or the payment of the price, in a contract to sell, ownership will not automatically transfer to the buyer, although the property may have been previously delivered to him. The prospective seller still has to convey title to the prospective buyer by entering into a contract of absolute sale. On the other hand, in a conditional contract of sale, the fulfillment of the suspensive condition renders the sale absolute, and the previous delivery of the property has the effect of automatically transferring the seller's ownership to the buyer. When there is non-fulfillment of the suspensive condition or non-payment of the price, in both contract to sell and conditional contract of sale, it prevents the supposed seller from being bound to convey title to the supposed buyer. So that's it for our review on the remedy of rescission in sales of immovables. Thank you for listening.